is Pure Vincy on Sweet Radio SVG, and my guest, this one is very dear to my heart. My guest is Honourable Justice Adrian Saunders. He's the President of the Caribbean Court of Justice. He was appointed in July 2018. He started private practice in St.Vincent and the Grenadines in the late 1970s, and in 1990 he established the firm of Saunders and Huggins here in St.Vincent and the Grenadines. He was appointed to the Eastern Caribbean Supreme Court in 1996, and then he was subsequently appointed to the Court of Appeal, the Eastern Caribbean Supreme Court of Appeal. He served as their acting Chief Justice between 2004 and 2005, and while he was there, he was involved in the court's judicial reform efforts, including the development of the court's first judicial code of ethics. He was the chairman of the Eastern Caribbean Supreme Court's Judicial Educational Institute from 2001 to 2004. And at this time, he is the course director for the Commonwealth Judicial Education Institute, the CJEI Intensive Study Program. He's also one of their directors. In 2005, he was among the first cohort of judges to be appointed to the Caribbean Court of Justice. He's a founding member of the Caribbean Association of Judicial Officers, and recently he has been appointed to serve on the advisory board of the Global Judicial Integrity Network. He serves as chairman of the Caribbean Association of Judicial Officers. He has written many articles, he has written books, and he is the consulting editor of the Caribbean Civil Court Practice. He has been a head boy of the St. Vincent Grammar School, a national table tennis player, president of the local table tennis association, and as Kenneth John said, he was a good enough wicketkeeper. He was also the chair of the St. Vincent Save the Children Fund, president of the National Youth Council, executive secretary, and eventually leader of the United People's Movement. He is also, above all, a husband and a father. Honourable Justice Adrian Saunders, welcome to Pure Vincy.
Thank you so much, Cleo. I'm very, very flattered by that very extensive introduction. Just one little note of correction, and that is that I'm no longer the course director at the Commonwealth Judicial Education Institute. When I became president, I had to, well, I didn't have to, but I thought it prudent to surrender that. And similarly, I also demitted office as the chair of the Caribbean Association of Judicial Officers in 2019. In each case, my very trusty and dear colleague, Justice Jamadan, took over from me. So he is the current course director and he's the current chair of CAJO.
Has huge shoes to fill. Justice Saunders, with all of the work that you have done already, you certainly have quite a number of cases under your belt. Do you have any idea how many cases you've sat on altogether?
No, it's a lot, because I've been on the bench since 1996, and in the Eastern Caribbean, both as a trial judge and then on the Court of Appeal, there was a steady stream of cases. The stream is not so fulsome at the Caribbean Court of Justice, where I've been since 2005, but the cases are of sometimes of greater complexity, and also because the cases mean so much more. You put a lot more effort. You have time to put more effort into them. I always tell people that a court like the Caribbean Court of Justice, or like the Privy Council for that matter, a final apex court, it deals with systems-wide correction. It looks at problems and tries to resolve issues that have a focus that goes beyond the parties before you, a focus that goes to the society as a whole. Whereas as a trial judge, you just deal with the parties before you and give judgment that would satisfy one party or the other. And as an intermediate court of appeal, you correct any errors of the trial judge.
Which of the cases would you say have had the most significant impact on you?
I think the cases that have had to do with constitutional law, and the impact is not so much on me. I suppose I'm unconsciously and now consciously interpreting your question to mean cases that have had a significant impact on society, as distinct from on me. Because for me, every case is, it's a case, you just deal with it. But some of those that have had an enormous impact on society would include cases like Hughes and Spence, in which I did in St. Vincent and the Grenadines. This was an appeal from, well, it was a conjoined appeal. There was a case Spence from St. Vincent, which was joined to a case Hughes from St. Lucia. And in each case, the critical issue was whether the automatic death penalty, the mandatory death penalty, was constitutional. It was important because that was never argued before, and everyone had hitherto assumed that when a statute says whosoever shall commit murder shall be hanged, that was inexorable, that was immutable, that was, something which was automatic. And it was being argued for the first time that it wasn't. The automaticity was unconstitutional, that there should be discretion in the judges to decide whether a particular murderer in particular circumstances should receive death penalty. And by a majority, 2-1, Chief Justice Byron and I were in the majority, and Justice Redhead was in the minority. We decided that the automatic death penalty, the mandatory death penalty, was unconstitutional, and that decision was upheld by the Privy Council. That decision triggered a new appreciation of death penalties throughout the Caribbean, throughout many parts of Africa, and it is probably the most cited decision that I have authored. At the CCJ, we've had quite a lot of cases that have had similar profound consequences. At the last elections in Guyana, there were some cases that we did regarding the elections results. Those cases, the enormity, the significance of the result, I think was more significant than the complexity of the legal issues as such. Guyana, of course, is a country that has had some trouble with racial tensions in the 1960s during race riots. And at the time when we were doing those election issues, the country was on a knife's edge. And so the decision that we gave helped considerably, along with efforts from CARICOM, which preceded the decision, to resolve the tension. And I think that it contributed quite a lot to preserving peace and stability in that country.
Quite an impact already. Justice Saunders, most people think that they are destined for what they become. And from doing the research for this program, I realized that you weren't even sure that you were going to be a lawyer, far less a judge of the Caribbean Court of Justice, making such impactful judgments and decisions. I understand that you just went to register, you didn't even know what you were going to do. And when Mr. Williams asked you, well, son, what are you going to do? You said, I don't know. And he's actually the one who advised you to pursue law. Have you ever wanted to opt out?
Absolutely not. What you said is absolutely correct. There were scholarship examinations to go to the University of West Indies, and like everybody else, I said, yeah, I'd like to get a scholarship to go to the university. When you had to sign up for the scholarship, Mr. Henry Williams said, well, what course? Well, that stumped me because I didn't appreciate that at the time. Just to sign up for the exam, you needed to say what you wanted to study, and I had not made up my mind on that. Law was definitely not on the radar. I did English, history, and economics at A-levels. And the idea of doing English, doing history, doing economics, coming back probably to teach, wasn't quite appealing, but I hadn't thought of any alternative. And so when Henry Williams saw that I was stumped, he said, well, look, they just opened a faculty in Barbados, so you could put down law. So okay, put it down. But from the very first lesson, I fell in love with the law, and I've never stopped loving it. Even though, every day you learn more about the law. I think it fitted in nicely with a number of things about me personally, which I gained from my parents. Both my parents were very service-oriented, very selfless individuals, and very altruistic. And law offered that opportunity to serve in that way. And apart from that, I was a good student at English, and law just suited, I think, my natural talents, my natural abilities, and my given instincts. And so I just loved it.
You said you never ever considered opting out. Not even when your grandfather said to you, there are no lawyers in heaven?
I know. Well, I didn't think of opting in because of that. I wasn't dissuaded from opting in because of that. Because at the time when Mr. Williams said to me, why don't you put down law? That flashed through my mind. My grandfather always used to tell my mother that there aren't any lawyers in heaven. but I didn't let that discourage me.
Have you ever been conflicted in terms of decisions that you've had to make or cases that you've had to consider and your religious beliefs?
I wouldn't say that, not at all, not on account of my religious beliefs. I've been conflicted sometimes because the law might prescribe one thing, and in your heart you might think that the law ought to be something else, and you have to, if you maintain your integrity and your oath of office, you have to do what the law says. Of course, you can find little ways to perhaps mitigate the harshness on the one hand, or to factor that aspect of the law that you have a difficulty with, but nevertheless you have to be true to the law. And sometimes there are conflicts there. I'll give you one little example. I know that in some countries, the penalty for indecency compared to rape is chalk and cheese. But there are some cases of indecency that are just as bad or even worse than some cases of rape. And to be constrained to have a very fierce offender not feel the full weight of the law, there's nothing you could do about it. And sometimes it goes the other way as well. sometimes the penalty for a particular offense. Well, that was the case with the automatic death penalty. Quite apart from the constitutional issue. Well, that was part and parcel of the constitutional issue. I thought that to give death by hanging in every case and not allow the judge to interrogate the personal antecedents of the offender or the circumstances in which the crime is committed was grossly unfair, because not every murder is the same. You know, you have murders for hire, you have murders in the course of robbery, you have murders where someone is in a situation of passion and the jury perhaps didn't buy the argument that you were sufficiently provoked. So the idea of giving the same penalty, a penalty which can't be reversed, a penalty which completely obliterates the prisoner, all that is left of the prisoner is a memory. There's nothing left. You've killed them. That didn't square with my own conscience, you know. And I thought that the Constitution was more in line with what I thought, with my conscientious approach towards that dilemma, than the mere law. And the law has to comply with the Constitution. So that helped me to resolve that issue in a particular way.
You are involved in a lot of reform work. Is there any possibility that those issues will come up for discussion and possible reform?
Well, this is it. The reform work that I am involved in involves reforming court procedures, court practices. It involves having judges get a new appreciation for this or for that, getting them to debunk unconscious biases and to rid themselves of those biases and to see things in an impartial light. But reform of the law itself is something which another branch of government does, the parliament, the government, and generally speaking, practicing judges shy away, and it may often not be prudent for them to actually be involved in those issues. Save and except if you are a judge, as part of a judgment that you give, you can say that it would be good if the law were to be changed to do A, B, and C. But outside of that kind of situation, that kind of law reform to which you spoke really is a matter for another branch of government and not the judiciary as such.
Understood. You work with the Caribbean Association of Judicial Officers, and one of the things that you work on is the development of gender-sensitive protocols for judicial officers. What is the extent of that program, and why is it at all even necessary to develop gender-sensitive protocols for judicial officers?
Yeah, this is a very critical issue now, and has been for some time. You know, for whatever reasons, throughout history, men have dominated women and have undervalued, have not appreciated the abilities and the desires and the natural inclination of women to be the best they can be as human beings. And that approach has led to, in fact, in some cultures, it is still very endemic. In our Western liberal democracies, over the last 50, 60 years, there has been a growing trend towards reversing that situation and allowing women to take their full place alongside men in being the best they can be in every respect. In the judiciary, there is still a considerable amount of work to do to get judges to that level where they understand and appreciate that legacy of bias and patriarchy and discrimination, often unconscious, that we have held towards women. It is vital that this is done in the judiciary because it is to judges that people come for justice. And it is only in the courts that as a last resort, you can go for justice. Beyond that is take up a cutlass and be vengeful and, take matters into your own hands. And so it is absolutely vital that judges and magistrates, judicial officers, those who people come to for justice, it is absolutely vital that they treat women, that they are that they're sensitive towards these barriers that women face. And so that requires considerable what we call judicial education. It requires an appreciation that equality can be substantive or it can be formal. You take the different. You take this, for example. We had a case there is a case from Belize, for example. The law said it was a Catholic school. Any teacher who has a child and is unmarried will forfeit the job. Now, there is this woman who got pregnant, and she was told she had to leave the job. And good girl, she went to court. And the judge, Justice Conte, says, no. This law is unconstitutional. The other side said, but no, this law is good for men and for women. So there's nothing discriminatory about it. He says, don't give me that rubbish. A woman cannot hide her pregnancy, but boys who father children are undetectable, usually. And therefore, the burden of this law falls disproportionately on women. And to that extent, it is a discriminatory law. That case brings out nicely the difference between formal equality and substantive equality. Somebody look at the law and say, well, it is equal, it applies to both man and woman. No. The burden of the law, the impact of the law falls disproportionately on women. And that is how we have to begin to interrogate laws. Not whether on face value they appear to demonstrate equality, but rather when you probe whether the impact of the law, the burden of the law falls disproportionately on one side. And if that is the case, then you need to you need to call that out, and you need to remediate that issue.
It's interesting that the example you gave was naturally about the imbalance between women and men, where women were more affected than men. In your work on this matter, do you find there are instances where men are adversely affected?
There may be some instances, but I think that there would be so few and far between that, for my part, they're not worth dwelling on. And this is something that comes up pretty often. You begin a discussion about domestic violence, and somebody would say, well, women are also violent towards men, and we need to do something about that. Yes, there are some women who are violent towards men. But the proportion is so small in relation to the other way that to get sidetracked into dealing with that misses the forest for the trees. And so we need to be very clear about what we want to do and not get sidetracked into those kinds of issues. But yes, there are instances where there's domestic violence, where men are victims. There are instances where I can't think of any, but there may be instances that there will be very few and far between. Why there will be very few and far between? That there will be instances where the law has that disproportionate burden on men is because for the most part, men make the laws, and they will be very sensitive and very attuned to that kind of situation.
We can't win, can we?